Unlocking the secrets of multi-generational planning, 7 ideas for your family. So what are the subjects we're going to cover here today? To set the stage, we're going to talk about the secret trust. They're going to give 7 multi-generational planning secrets to illustrate the power of these strategies. And they're not secrets to everybody. The 7 examples we're going to give: how gifting to your parents can protect you and your kids, how grandparents can support their grandkids in very tax efficient and wonderful ways, how you can help your kids, your adult kids, to buy a home or a condo, how to keep property taxes low and to save the family home for future generations. Because if you don't communicate across generations, you might lose your house when it goes to your kids, because there's a new law in California that has some dramatic effects. If you listen to us regular, you know what we're talking about. The secrets of the 1%, the ways that you can use entities or LLCs or other structures to discount the value of your estate and to potentially avoid estate taxes if you face those. We'll talk about what you can do. Number 6, how you can protect assets and pay for quality long-term care. And lastly, how you can avoid capital gains taxes and support charities in win-win ways within the family. So Mike, why don't you lead us through what we mean by multi-generational planning? What is that? And I want to start calling this like estate planning 3.0.
That's a good concept because we are kind of taking it to a higher level. It's simple, and yet it isn't. It's simple because once you open your eyes to these planning tools, you say, yeah, obviously. But most of the time, planning is done on kind of a singular level. The attorney works with the client. What's the client going to do? How are they going to leave it? And that's it. So again, the idea here is to coordinate estate planning, coordinate financial planning across 1, 2, 3, even 4 generations. It's not just linear, it's multifaceted. It's no one size fits all. So here we have just a few of the articles that we've published. Mark and I co-authored 2 of these articles about multi-generational planning. One of them is from the current issue of the National Academy of Elder Law Attorneys, which is a national organization that serves and provides a lot of resources to attorneys in the country. So again, we're trying to get the word out there, get more attorneys to think this way, have a rippling effect for the benefit of people everywhere. But we are national leaders on this concept. There's no question about it. We're one step ahead.
You're going to see, as Mike pointed out, all the powerful ways that if we work together, we can save so much. We can keep people in much better situations. We can protect what we've earned, and we can avoid unnecessary taxes. But again, it's about quality of life in the grandkids. So we want everybody to reframe how they think about estate planning, and it should be multi-generational wherever possible. Estate planning 3.0. That's where we want to take you. What is the secret trust that the 1% use to protect assets for multiple generations? This is an incredibly powerful tool. And to illustrate what it is, the tale of supercharging a plan. Larry's father leaves him $2 million. During Larry's life, he gets divorced. He also gets sued after a bad car accident. When he passes away, that $2 million is gone. Nothing there for his kids, and of course, nothing there for his grandkids. Wyatt, same situation starting out, $2 million for his benefit. He also gets sued. He also gets divorced. But when he passes away, there's $6 million there from that $2 million for his kids. And when his kids pass away, that's turned into $18 million. So an $18 million difference, even though they basically live the same parallel lives. What is the difference? What are we talking about here?
So let's give it away. The Family Protection Trust. Generically, it's called a dynasty trust. I'll quickly mention that Bernie Sanders on his platform, this is public record, love him, hate him, whatever, this is simply a fact that Bernie felt strongly that dynasty trusts should be outlawed because they so effectively protect assets for multiple generations from exposure to tax. So that's the introduction to talking about the topic. And Mark kind of, lives and breathes this issue. So Mark, let's explain and talk about the beauty and the power of the dynasty trust.
Yeah, and it's so important to understand this. When we talk about multi-generational planning, having this trust in place is often a key part of it, whether you're ultra high net worth or not. And I think that's the big point that we want to make. You do not have to be high net worth or ultra high net worth for this to be powerful. And we'll show you why. I think a lot of people have the misnomer that, if I'm not a multi-millionaire or 100-millionaire, I don't want to think about this. There is no reason why everybody shouldn't have the power of these trusts for their family. So here, instead, let's say you have 2 kids. Instead of leaving assets to your kids, you would create a family protection trust for your first child, a family protection trust for your second child. You leave assets to the trust. You wouldn't leave them a penny. Why? 3 big reasons. So 1, divorces happen, right? Between 40 and 50% of marriages end in divorce. So there's various stats around that. And if you leave assets directly to your child, they commingle it, 50% could be lost to their ex. Creating a trust and leaving assets to the trust keeps it separate. It should not be lost in a divorce. 2, if your child is sued, if they inherit assets directly, there are no protections for that. It is fair game. If it's in one of these trusts, there's a barrier. You created a barrier to make it a lot harder for litigants to get at that money. So you're creating sort of a structure and almost an insurance policy to make it a lot harder for litigants to go after that money. 3, this is super powerful. When your child passes away, the assets in that trust, plus the growth and the value of those assets during their life, subject to some limits, is not part of their taxable estate. So right now, you can pass $12.92 million per person to your heirs without any estate taxes. But the exemption is going to drop in the next couple of years. And who knows what the estate tax rules will be in 10 years, in 20 years, in 30 years. By creating this trust now, you're taking a big chunk of assets, what you're leaving your kids, and it's not going to be touched by estate taxes when your kids pass away, when it goes for the benefit of your grandkids. It can save hundreds of thousands or even millions, even if you don't think of yourself as high net worth now. Think about that future growth. And you might think, well, this is all great, Mark. I love this idea, Mike and Mark. Great idea, but I don't want to tie my kids' hands. I don't want to make my life too complicated. I don't want to make their life too complicated. They can be their own trustees. They can be in charge of this trust for themselves. There's situations where they might want to step down, but you don't have to tie their hands. So they can be in charge of these trusts for themselves. So it's extraordinary peace of mind, extraordinary protection. And Mike, how long do these trusts last?
In a way, and yet the limitation is in California, they last for roughly 100 years. 2 or 3 generations. There are some states where they last forever. For a number of reasons, we usually want to base these in California, even with this modest limitation. But if you think in terms of 2 or 3 generations, I mean, that's a lot. We're talking about the grandkids and the great-grandkids. We recommend them for virtually everybody.
And this should not just be for the ultra wealthy. You do not have to be ultra high net worth for this to be valuable. If you just have a house in California, it's likely worth it. So let's just go back to that mystery really quickly. Let's unravel it. Larry, $2 million inherited, divorce lawsuit, all of it gone. Wyatt, on the other hand, $2 million divorce lawsuit turns into $6 million when he passes away and $18 million when his kids pass away for his grandkids. The difference, Larry inherited it directly. So when he got divorced, he lost 50% of it because he commingled it. And when he was sued, there was no protection around it. He ended up losing the lawsuit, lost it all. Wyatt, on the other hand, the assets went into a family protection trust. When he was divorced, the assets were separate so that they weren't lost to his ex-spouse. When he was sued, the barrier freaked out the person suing him. They didn't go after the money, settled for less. The money stayed in his estate. It grew during his life to $6 million because he just invested it decently in the stock market. Maybe he bought a house with it. So it became $6 million. His kids were protected from divorce and lawsuits. So the money was allowed to grow during their lives. $6 million to $12 million to $18 million. The power of compound growth was able to take hold. The difference of literally starting out with not that much, it can be tens of millions over time. So we want you to be one of those families that put these into place now so your kids and grandkids really benefit from this, because we think there's going to be a big divide between the families that create these and the families that don't. Fair or not, we want you to be informed about them. So be aware. Now let's talk about multi-generational planning secrets, a situation where you might gift money to your parents to protect assets. So Dad, you probably would love that idea. You want me to give you some assets? Why don't we talk about what this really means? And let's give an example.
So let's talk about multi-generational planning idea number 1, how a successful, arguably wealthy child in her 30s, 40s, 50s, 60s might want to give assets to her parents. Again, intuitively, it doesn't make sense, but it does. Here's why. Sarah is successful. She has a large estate. It's ultimately probably going to be exposed to the estate tax because remember, in 2026, it goes down to only take the word in context, only about $6.5 million per person. So if she has a larger estate and it's growing and she's in high tech and everything is going well, her estate is going to continue growing. There's also the possibility that the level of estate tax protection is going to drop. She may be concerned that she's going to be sued because of the assets that she holds. So one of the things she would consider is transferring a significant portion of her assets to her parents. So the assets are passed along to her parents. She can make gifts to them. She can use this thing called the annual exclusion, or she and her husband can give up to $17,000 each parent per year. So if there's 2 parents, that's like $68,000 a year can be given away. If she's really motivated, she can make a gift of stock, of other assets that might appreciate in value. Now, what would the parents then do? And the presumption here is that the parents do not have a huge taxable estate. Most parents don't. I mean, let's face it. Okay. Okay, so the parents then have those assets in their estate, in their trust, right? They create a family protection dynasty trust for their daughter, Sarah. They modify their trust. It says the assets don't go to Sarah when they pass away. The assets go into the family protection trust created for Sarah's benefit, the dynasty trust. So then, upon their passing, number one, because those assets are in the parent's estate, we get this thing called the stepped-up basis. Now, if Sarah held on to the assets, she has a very low cost basis. She paid little for the asset, for example. It grew in value. If she kept them and sold them, she'd have capital gains tax. If she later inherits them from mom and dad, the basis increases to reflect the market value on the date of death. She could then sell them, pay no capital gains tax. Number two, far more importantly, the assets that are left in the dynasty trust are now excluded and protected from Sarah's taxable estate. One of the major benefits of the dynasty trust approach. So maybe there's $1, $2, $4, $5 million in that trust. If Sarah retained those assets, they would be part of her taxable estate, creating exposure. By having them conveyed by two steps into the dynasty trust, they're not in her taxable estate, nor will they be in the taxable estate of her kids. We're building in this high level of protection from litigation. If Sarah, we didn't mention this one, but if she gets a divorce, the money that's left in this trust is segregated for her. We've got estate tax protection. We're going to get the stepped up basis for the assets that she gifted. It's an example of creative thinking about how we can take advantage of there being two educated members of a family, two generations where they can coordinate their planning.
I mean, who wouldn't want to get a stepped up basis and get protection for divorce and lawsuits and estate taxes if they can get that? You know, there's obviously a lot of other issues, but this is next level, expert level, 1%er advice. You are now part of this. You are an insider. You understand this. So multi-generational planning secrets of how grandparents can support their grandkids tax-free in win-win ways. So Mike, you're the grandparent here. Why don't you talk about what we mean here and some examples of that?
Sure. So, is it not self-evident that most grandparents would like to help out their kids, but maybe more importantly, their grandkids? The grandkids are perfect. The kids have all kinds of flaws. The grandkids haven't had time to develop their flaws. So what can the grandparents do? They can do this for others, but particularly for grandkids. Number one, ways to transfer assets out of the grandparents' estate without having to report the gifts. They're really not counted as taxable gifts. Paying medical expenses for the grandkids. Kids too, but again, we're really focusing on the grandkids. Paying tuition for secondary school, high school, private high school, college, and so on. So there's many opportunities of providing support for that next generation, removing assets from the taxable estate, and having an incredible level of satisfaction for doing so. So again, the key when you're paying medical bills and tuition, you don't write the check to the kid who pays the bills. Those checks, those payments have to be made directly to the entities that provide the services. This can be a tremendous source of resourcefulness and asset protection. Again, because we're removing assets from what may be a taxable estate for grandma and grandpa, and we're doing this for the benefit of the grandkids, which certainly helps and protects the kids, the parents, the one in the middle, the parent of your grandkids.
They're talking about how birth rates are going down in Western society. Certainly in California, the population of California is getting older and older. There's fewer and fewer kids. One of the big reasons is it's so expensive. So if grandparents can help out, it's just such a wonderful way to help out while grandma and grandpa are also still alive. And there's a really powerful trust that can be created as well to take advantage of annual gifting. So Mike, again, you're the grandparent here. Why don't you lead us through the really powerful trust that grandparents can create to support grandkids tax-free?
And this is the trust that I have long referred to as the grandparents' delight. It's actually called the Crummy Trust. Forgive us for the name, but it's named after a tax court case from many years ago. It's called a Crummy Trust. You may be well aware of 529 plans where you can put money into an account to pay for the cost of education, and that can be fine, but this approach is more flexible. We prefer it as a general matter. You don't have the tax breaks that you get with the 529 plan, but we think the benefits of the Crummy Trust outweigh that benefit. Now, what does it mean? This is a trust you set up for the benefit of a grandchild. You use the $17,000 annual exclusion. Again, if there's grandma and grandpa, that's $34,000 a year. That goes into this trust. It's got to be done very creatively. It isn't just writing a check to the trust. 2 or 3 steps have to be taken, totally manageable. But the point is that over time, if it's $34,000 a year, after 10 years, you're up to $400,000 or $500,000. It's significant. The money can be used for education, but importantly, unlike the 529 plan, the money can be used for education. The money can be used for healthcare. The money can be used for housing. It can be used to take care of that grandchild. And unlike, again, 529 plans where it kind of ages out when your kid is done with school, you can set the terms. If you want that trust to last until your grandchild is 25, 30, 35, any age, you can do that. You can identify the trustee of that trust, who may be the parent of that child. We're being a little bit creative here. How can we make these gifts in a way that's responsible? Sometimes you kind of worry, and by the way, we're not fans of these Uniform Transfer to Minors Act accounts where you put money into an account and at age 18, the kid comes into 20, 40, 80, $100,000. Let's not do that. So we're cognizant, we're aware, we want to be creative, and we want to be protective of multi-generations. That's the whole point here.
Multi-generational planning secrets. How can you help an adult child to buy a home the right way? Because there are wrong ways to do it. I want to give you some examples of how you can do it where the help that you give them is protected, and it's so powerful. So the idea here is parents want to help their adult children to buy their first home or condo, wherever it is. And let's just be clear, housing is so expensive around the country. The Bay Area, LA, all of California especially, really everywhere in the country, it's expensive. So we have many clients, one way they want to help their kids out is they want to help with a down payment or other assistance for buying that first home. What a wonderful way to help somebody while everybody's still around. You got to communicate about this and coordinate. What if you're worried that, well, I love my kid, I love his or her spouse, their husband or wife, but divorce happens. I don't want to know that all this help I'm giving could be lost in a divorce. We can use family protection trusts, generically known as dynasty trusts, as part of this. So we've talked a lot about dynasty trusts, about our version of those family protection trusts. It doesn't have to be the whole purchase. Sometimes people think, well, if it's trust, I don't have to buy the whole house, put the whole house in the trust. I don't have the money to put that all down. There are ways where we can divide it up. An example here is, let's say mom and dad want to help with a 20% down payment for a house, but the kid and their child's wife or husband are going to finance the rest. Well, you can say, look, the help that we're going to give you, we're not going to just give that to you. We want to protect it. So they can literally, if you put 20% down, you can put that 20% for mom and dad can go into a family protection trust. So that portion of the house is actually owned by the trust. The rest can be owned by your child and their husband or their wife. And what does that mean? Well, it provides some incredible protections. So whatever you've contributed as parents towards that purchase, it eventually goes in that family protection trust, and you have some protection against divorce, some protection against lawsuits, and it's not part of your child's taxable estate. And yes, dynasty trusts absolutely, family protection trusts absolutely can hold real estate. You can buy and sell real estate within the trust. A really, really powerful way to help a child out and to protect what you're helping them with. Anything you'd add here, Mike, as the parent in that potential role, helping adult kids, which we always appreciate. Any additional thoughts you have?
Yeah, it's just that, this is not being negative about a daughter-in-law or a son-in-law. The divorce rate hovers around 50%. And ultimately, when you use this tool, remember, this family protection trust is ultimately for the benefit of the grandkids. That's why, daughters-in-law and sons-in-law, they say, cool, we know this much is going to be protected for my kids. So again, it's win-win. We always include the daughter-in-law and son-in-law in the discussion. If it wasn't for this down payment, they wouldn't be able to buy a house. I mean, there's no negative here at all about this approach. It's all positivity, creating options for the next generations.
We have to talk about property taxes in California. And if you watch our other talks, we hammer this every day. Literally yesterday, I had some clients come in. They just updated their estate plan with an estate planning attorney who didn't even flag this as an issue. And we have to say that's a warning sign. If you're working with a different firm and they don't even flag property taxes as an issue for you as when properties go to your kids, that's a concern, because you need to be aware of Prop 19 and what it means and how we can defeat it. Let's just talk about what the new law is and why Prop 19 in California is in some ways the demise of Prop 13, at least as it pertains to parent-to-child transfers. Prop 19 is now law, and it became law February 15th, 2021. The deadline is passed, but we still can deal with this. That's a key point. But what happens now? So it used to be that when a parent passed away, they could pass their primary resident to their children and a good portion of rental or other property to their kids with no increase in property taxes. Prop 15 58 in California used to protect that. Prop 19 really undid that. And now, if you pass your primary residence to your kids, there are limited protections from property tax increases if your child lives in the house. And if they don't live in your house and just inherit it, property taxes can be fully reassessed at fair market value. Rental properties, unless we plan ahead, there are zero protections from property tax increases if you have a duplex or a fourplex or a vacation rental or a cabin. All of those properties will be fully reassessed at fair market value when they go from parent to child, unless we plan ahead. And what can that mean? That can be a 1,000% increase, a 2,000% increase. I talked to clients yesterday where they're looking at a $3,000 a year property tax spiking to about $45,000 per year if they don't plan. And that's even if their child lives in their house. If you don't plan, if you just put your head in the sand, your kids are going to face this. But again, without planning, there is likely going to be a full reassessment of property taxes for any real estate you have. So you've got it for a long time. That means the fair market value is way higher than the property tax assessed value, because Prop 13 keeps that low as long as you're alive. When you pass away, or if you just give away property now, if we don't plan massive increases, and again, as I mentioned, your home gets some protections. If your child lives in your home after you pass away, the first $1 million in fair market value above the assessed value is protected from a reassessment. So if your house is worth under $1 million, it may not be an issue if your child lives there. If they want to keep it as a rental or something, or a way to support their family, no protections. And if your house is worth more than $1 million, if it's worth $2 million or $3 million, even if your child lives there, it could be a massive increase in taxes unless we plan. Mike, why don't you talk about the solutions that we've developed?
We have to be sensitive to asset transfers and interest in transfers that do not generate reassessments. If it's less than 50%. If you're not giving up control, we can avoid the reassessment on the first transfer. We may want to transfer that asset out of the estate and have it as a complete gift, which has to be reported to the IRS. Sometimes, if it's a smaller estate, we want it in the estate so we can get a stepped up basis.
Sorry, there's no one size fits all, because as Mike alluded to, we have to weigh property tax issues with capital gains tax issues, with estate tax issues. And we've seen hints. I had a client the other day come in and they showed me what another attorney was talking about. It's not to denigrate other attorneys, but we've seen some bad advice out there about Prop 19 that we know will cause issues. And we want to make sure that you're not solving one problem, but creating a much bigger one. So don't try this at home. Little mistakes in the process can result in hundreds of thousands of dollars in tax increases, but we can help you. So let me just give one example of why it's so powerful. So let's just say there's one property, and yeah, it's worth $3.3 million in this example. Now in the Bay Area or parts of Southern California, that could just be a decent single family home, as crazy as that is. But let's say it was worth $3.3 million and the assessed value was bought many decades ago. So the assessed value for taxes is only $300,000. If you don't plan ahead and that property just goes to your kids with no planning and taxes are reassessed, we are talking about over 10 years, $360,000 in additional property taxes over 30 years if your kids keep it through the rest of their lives. We're talking over $1.3 million in additional property taxes. And property taxes are mostly not tax deductible. You can only deduct the first $10,000 in property taxes from your income taxes. So really, to pay that $1.3 million in extra taxes, your kids may have to earn like $2 million extra dollars just to pay for the money that's going to the state that your kids get nothing back for. I mean, you may say, hey, society, it's good if we have higher taxes, and that's up to you. But we have the choice. We can protect against this and save your kids. I mean, we're talking hundreds of thousands or millions of dollars. So talk to us if you want to explore this for your situation. We're helping so many families with this. There's a lot of ignorance about Prop 19. So I just want to hammer home that is a multi-generational issue. The last two clients who came in for us, they dragged their parents in the meeting. He said, hey, mom and dad, I want to live in a house in the Bay Area. I want to live in a house in Los Altos that I grew up in. I'm a teacher. I can't afford a property tax increase. Can we work together to keep this low? So we've had many adult children alerting their parents. So if you're in that position, let your parents know about this. All generational planning secrets, tax planning for the 1%. But really any family should be aware just of the amazing tools that we have out there to protect assets. So Mike, talk to us about that.
You might be kidding yourself about the size of your estate. When folks come in and talk with us and they roughly estimate the value of their estate, they'll consistently, they'll be 25% lower than reality when they come up with their estimates. So you have to be objective and realistic about what your estate is worth. The current level of estate tax protection is very high. It's almost $13 million per person, like $26 million for a couple. Very few people are above that. But around here in the Bay Area of California and in Southern California, your home alone could create a taxable estate for you. So you have to accept that fact that there's value there and it could be exposed to the tax, because in 2026, it goes down to like half of the current level, $6.5 million per person. But if you're a single person and you have a nice house, you may have a taxable estate whether you want to accept it or not. So we have to think about this. There's also the possibility that the level of estate tax protection will drop. That could happen. There are multiple steps that you can take. Let's go through some of the basics. You can utilize this thing called the $17,000 annual exclusion. You can give that money away to any number of people year after year, and you don't have to report that to the IRS. So if you're blessed with a larger estate, you can make these gifts, removing these assets from your estate, maybe utilizing that crummy trust that we referred to earlier for grandkids. It's a tool that sits there for the taking. You can pay medical bills. You can pay tuition. You're helping family members out. You're reducing the size of your taxable estate. Now, that's the low-hanging fruit. You don't have to really think about those. They're obvious. You just have to know about them and then take advantage of them. But what can we do that's a little bit more sophisticated? We do call these the tools of the 1%, because folks who acknowledge that they have a larger estate tend to talk with us and we tend to deal with it. But again, you have to think about it. Think about the growth of your estate in coming years. Real property around here just goes up whether we like it or not. And maybe there's a lull in the growth right now, but it's only a lull. They're going to keep going up. So let's look at this example. Dave and Sarah, they have two. Here's Sarah again. Hey, she's doing well. Okay, their estate is already about $25 million. The estate's growing. They're concerned about tax. They want to protect assets for their kids and for their grandkids. So the first thing they're going to do, they're going to set up dynasty trusts for their two kids. Then we get into some of the more sophisticated approaches that we can utilize. One approach utilizes discounting. An extremely simple example is the following. We might set up a limited liability company or a family limited partnership to hold a particular asset. And then the parents who start out owning the entire entity, they start giving away portions of that entity. Mom and dad remain in control of that entity. They give away limited interest to the kids. If a kid has a limited interest in their dynasty trust, well, they have no control over that. They can't sell it. Mom and dad own the property. They can't compel a distribution. So their ownership interest is actually legitimately limited. They just can't do that much with it. If it was 10% of a $100,000 asset, that would seem to be worth $10,000. In this concept of discounting and tax planning, it's not. We would take at least a 20, 25, 30% discount when we look at the value of their interest. So rather than holding $10,000 in my super simple example, that would really be valued at maybe $6,000 or $7,000. If we take that up to $1 million,
multiply it by thousands, and that's these are not taking huge risks. These are accepted by the IRS, where you can essentially make hundreds of thousands or even millions vanish from your estate. You might not consider yourself high net worth, but again, the estate tax exemption could be dropping in the next few years. It could drop even more to where just owning a house in parts of California could present this issue. And these strategies could be relevant to you. So we want you to be aware of what they are. We've done it for so many clients. It's just extraordinary what we can do. And Mike wrote a book about this. It's called Beat Estate Tax Forever. It's available to our clients. It's also actually available on Amazon. But usually we talk a lot about family protection trusts, generically known as dynasty trusts, because they're often part of the plan. You want those ahead of time. But we can use LLCs and special irrevocable trusts. There's GRITs, there's GRATs, there's all sorts of personal residence trusts. And I think the main point we want to make is there's so many techniques we can use to protect assets and really to make assets legally vanish from your estate when it comes to estate and gift tax exposure. It's just so powerful. We do have a specific webinar on our Gilfix Law YouTube channel called Estate Planning for High Net Worth Families. There's a couple webinars we've given on that if you want to see more detailed examples of what we're talking about here. And it requires coordinating across generations. You don't do this unless you're talking to your kids or kids are talking to the parents. You do not do this without including your kids or your parents in the discussion. Any notes, Mike, as we think about these issues, the importance of communicating ahead of time about this and how multi-generational planning is part of this?
We are cognizant of the property tax issues presented by Proposition 19. So some transfers for estate tax purposes, create problems with property tax. So, we have to coordinate. We have to look at that. We have to think about capital gains tax. What assets do we want in the estate for the stepped up basis? What assets may make sense to transfer and not worry about that?
How to protect your assets and pay for the cost of long-term care. Because the fact is, 80% of us over the age of 65, of Americans over 65, are going to need some form of long-term care. It used to be 70%. I actually recently saw a study that it's more like 80%. And what does long-term care mean? We just mean care that's not going to go away. If you break your leg, you're in the hospital for a couple of days, rehab, that's care, but it's not long-term because you're going to get better and you're going to leave. Long-term care, just as I think about it, is just some form of care. And there's a lot of different categories of it that you're going to need basically for the rest of your life. And maybe you're going to need more and more care over time. Most of us do. Mike and I co-authored a book, Facing the Reality of Long-Term Care, about this. We think about this day and night. There are some government programs that can help pay for the cost of long-term care. There's a big misnomer. A lot of people think that Medicare, which has no asset limit requirements, we all get that as we get older. A lot of people think that Medicare will pay for long-term care. It will not. Medicare will not pay for long-term care. Medi-Cal, the California version of the federal Medicaid program, can help pay for the cost of long-term care. And that's really important to understand those distinctions, because the programs that will help really pay for long-term care generally have asset limits. And what does that mean? It means if you have too much money in the wrong category of assets and savings or investments or rental property, you might not be able to get these really important benefits. Nursing homes, if you need that, can cost we've seen as high as like $20,000 a month per person, but there's certainly over $8,000 or $9,000 no matter where you are. Extraordinarily expensive. So what's an example of how adult kids can be involved in that? Well, in some cases, parents will transfer assets to the kids ahead of time, and we have to be very careful about this to get under asset limits. And the kids can take the money that mom and dad transfer them and set up special needs trusts. They wouldn't do it dollar for dollar. They wouldn't do it right away necessarily, but they could take other assets and put money. Mom and dad make some gifts. Kids set up special needs trusts that are designed to be there to support mom and dad no matter what happens to the kids, but they're trusts that are designed that don't interfere with Medicaid eligibility or government benefits eligibility. So there could be $100,000, $200,000, $300,000, $1 million in a trust the kids create for the parents. There are so many other ways we think about this. Medi-Cal eligibility rules in California are changing. On the surface, it looks like they're getting less and less strict. It looks like January 1st, 2024, we may not even have an asset limit anymore in California. So maybe we won't have to worry about this, but we don't know if that's going to last. I don't know if billionaires should be eligible for Medi-Cal, which is what the new law will technically say. So you need to be aware of this, and I think it's really important ahead of time. Mom and dad and kids need to have sophisticated, durable power of attorney documents in place. And what do I mean by sophisticated? So any core estate plan should have 3 documents: a living trust, power of attorney, durable power of attorney for finances, and advanced healthcare directive for medical decision-making. The power of attorney for finances governs day-to-day finances, but what if you become incapacitated and it makes a lot of sense for some of your assets to be transferred out of your estate to become eligible for government benefits? Your durable power of attorney document needs to explicitly give your kids or whoever you've named the power to do that. Your family probably can't do this type of planning if you become incapacitated. So we need to think ahead, and we need to communicate as a family, because this is about saving assets to make sure there's plenty available to take care of mom and dad if they need expensive care in ways that government benefits won't cover it.
I've only been working on this issue for about 50 years. It was 1973 when I created the first free legal aid program for elders in the country here in Santa Clara County. And these are the issues we started dealing with. So, we talk about asset protection. Let's be really clear. The real focus is on quality of care. That's the focus in every plan that we put together. And that's why Mark mentioned the special needs trust. Objectively, if you have a good family situation, trusted family members, asset transfers, becoming eligible for Medi-Cal means you're creating options. It doesn't mean you're necessarily going to use that, but you're creating opportunity. So if utilizing Medi-Cal and getting quality of care works, you do it. If using Medi-Cal and doesn't get you quality of care, if you have alternatives, if there's money there, you don't rely on Medi-Cal. So we're not, money, money, money. It's really quality of care. And most parents think, I really don't want to burn through everything on the cost of a nursing home. I want something to be there for my kids. I mean, that's a consistent theme that parents have for their kids and their grandkids. So, it's complicated, multifaceted, tax issues galore. We pride ourselves on being a step ahead and coming up with the best solution. So, this is multi-generational idea number 6 on steroids.
Kids, you need to talk to your parents about this. Parents, talk to your kids about this. Because when you don't talk about long-term care and what a parent's or grandparents' goals, wishes, dreams, fears are, you're not going to be able to put great care into place. It's so important that we communicate ahead of time before a crisis, before that Alzheimer's diagnosis, or before dementia gets worse, or before a heart attack. Good thing to talk about around the holidays, maybe 4th of July, you're having the family barbecue, maybe just talk. Multi-generational planning secrets, how to avoid capital gains taxes and to support charities and to involve your family in win-win-win ways. We love the idea of charitable giving. I know, Mike, having run a nonprofit for 10 years, your first 10 years out of the Stanford Law School, you created America's first free legal aid program for the elderly. You were immersed in the nonprofit world, helped other people start nonprofits throughout the country to serve the elderly with free legal services. Let's talk about charitable giving. Why don't you lead us through that?
Our focus for the moment, in part, is on capital gains tax because, if you have an asset, a second piece of property, some stock that isn't giving you much income and you need income, you get a little worried about these things and you're tempted to sell because you need the money. If you sell, if it's gone up in value, what happens? You have capital gains tax exposure. Combined state and federal, it's a little over 30%. I mean, that's a lot. So if you sell an asset worth $1 million and you lose $300,000, that doesn't feel good. Then you have $700,000. That part's good, but you've given up a lot, and that doesn't always fit. So one option, one of the many ways of avoiding capital gains tax, not the only one, is to create something called a charitable remainder trust. The idea is this. You take the asset, you put it into a trust. It says ultimately whatever's left in this trust is going to go to a tax-exempt organization, the charity of your choice. Once the asset goes into that trust, it's sold. Now, because it's going to go to a charity, to a tax-exempt organization, when the asset is sold, there is no capital gains tax exposure. So in my simple example, the asset is sold. There's $1 million sitting there. The trust then says that you're going to get a rate of return, let's say 6%. Every year for the rest of your life. So that's a significant distribution every year, year after year. There's a number of different ways you can organize that, but the point is you're converting an illiquid asset into an income stream for you. You're ultimately going to benefit the charity of your choice with the money that remains. It can also be structured to benefit your kids. It involves your kids as well, particularly if you're setting up your own family foundation, and it can be the beneficiary. I love the idea of getting the next generation involved, kind of reinforcing and learning about your values. This whole approach can reflect and reinforce family values. Many people do it only for the tax reason. Many people do it only for the charitable giving reason. But again, you're achieving two important goals at the same time. Charitable giving, supporting the organization or organizations, plural, of your choice, locking in a significant income stream for yourself for the rest of your life. You're also removing that asset from your taxable estate, by the way, by converting it into this charitable remainder trust.
And if you create a family foundation, for example, your kids can be managers of that after you're gone. So, or even while you're still around, they can be managers and they can even get paid a reasonable salary for the time they spend on that. So it can provide some income, but their focus is on how can we use this money for good? How can we use this money to support wonderful causes? So many win-win ways to do this, and it can be tax benefited and can support causes you obviously really care about. So we love that idea. And it's a way where you have to work across generations if you want to involve your kids in this, and you should talk about this. We want to make another point. We believe in integration wherever possible. We think this is what we're going to start calling estate planning 3.0. We're going to define these in other videos soon. But is your financial plan, are you communicating with your kids, your grandkids? If you're a kid, are you communicating with your parents about asset protection, about property tax issues? And is your financial plan integrated with your estate and asset protection plan? And we are developing some new tools where not only do we want to communicate across generations where we can, we're developing some partnerships with some key financial advisors where we're going to work hand in hand directly for clients in win-win ways. So talk to us. If you're looking for a new financial advisor or review, talk to us. We're developing some amazing tools where we think we can bring all these tools to bear. If you have a planner, we want to be able to talk to them too. If there's someone you really like working with, we want to be able to talk to them as part of your planning team. Regardless though, we think the next iteration, the next generation of estate planning should be one where families talk to each other, parents, grandparents, kids, and where financial advisors talk to estate planners. This has commonly been done for ultra high net worth families for a long time. We think every family should benefit from having this integrated team. It's not just Mike and I. We have Nick Klingenberg, Renee Conrad, Francis LaPaul, our tax guru. We have a multi-generational team. We may be expanding our team soon. We have plenty of clients. We want to make sure we can serve every client extraordinarily well. So we all work together. We communicate as a team. So if you're working with me, you're also getting the wisdom of Francis DePaul and Mike and Renee and Nick. If there's any issue I'm not sure about, we work as a team to solve it. It's easy to find us. Gilfix.com. 650-493-8070. Hey, we hope you enjoyed that. Like, comment, share it with someone who could benefit from this. Stay tuned for so much more free legal educational content on the Gilfix Law YouTube channel. Subscribe. Let's be in touch.